Most of us have bought into neighborhoods that have existing zoning. I've talked to the late Professor Bernie Segan from University of San Diego, who was an opponent of zoning. Yeah. But even he admitted that you have a right to expect the existing zoning to last. So we've kind of accepted, even those of us on the very strong pro-property rights have, these things have been with us a long time, and we know the existing rules when we buy a house in a neighborhood. We understand about setbacks. But we don't understand the fact that our house can be taken and given to Costco. And most of us do also accept what the Constitution allows, eminent domain for public use, provided due process is given and just compensation is paid. What we're having a problem with is public use going from a road, school, something owned by the public that could benefit anyone in the public, to private enrichment. And that's really tough to take. And as courts have ruled, it means the obliteration of property rights. If, as cities argue, as they did in the city of New London, argued that a higher tax take is a public use, in the oral arguments, the attorney for the city of London said, yes, it would be acceptable to take a Motel 6 and turn it into a Four Seasons, because Four Seasons pays more than Motel 6. So if that's acceptable, then there are no property rights, because Costco's always going to pay more than you will or I will.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.